Today, we're diving into the EU's landmark AI Act, but we're focusing on one huge problem it faces. I mean, how do you even begin to regulate a technology that basically reinvents itself overnight? Well, the EU thinks it has a secret weapon, a really clever bit of legal engineering called Article 7. All right, let's get into it. This is the million-dollar question for regulators everywhere, right? We've all seen it happen. A new AI model drops, and boom, the entire landscape just shifts. The problem is, laws get written on a timeline of years, not months. So how on earth do you bridge that gap? And that really is the core of the problem. By the time a law is passed to deal with a specific AI risk, that technology has already moved on, creating totally new challenges we hadn't even thought of. This whole dilemma meant that lawmakers had to find a completely new way of thinking about legislation. So, what was the UU's big idea for tackling this massive challenge? Well, their goal was to create what they call a future-proof rulebook. And the entire strategy, the whole thing, really hinges on one critical piece of this law, Article 7. You can think of it as the engine that's designed to keep the AI Act relevant and adaptable for years to come. It's the thing that makes this rulebook less of a static document and more of a dynamic, living framework. So let's break down what Article 7 actually is. Probably the best way to think about it is as the guardian of something called a living list. Okay, so at its core, the AI Act puts certain AI systems into a high-risk category, and those systems have to follow some really strict rules. That list of high-risk systems is called Annex III. Article 7 is this special mechanism that lets the European Commission add new things to that list as technology changes, all without having to go through the years-long pain of passing a brand new law. And that is the crucial point. The list of what's considered high risk isn't carved in stone. As new kinds of AI pop up and we discover new potential risks, this list can actually grow and change. It's designed from the ground up to be a living, breathing document. So how does it move so fast? It uses a special tool called a delegated act. Basically, this gives the Commission the power to update specific, kind of technical parts of the law pretty quickly. It's way more flexible than a full vote, but, and this is really important, it's not a blank check. The European Parliament and the Council still have oversight, so there are checks and balances built right in. But this power has some very clear limits. What's so interesting here is the distinction the law makes. Using that fast delegated act, the Commission can add a new use case inside an existing area. Think of a new AI tool for hiring, which falls under employment. But if they want to add a whole new area of risk, let's say environmental AI or something, that requires the full, slow, deliberate legislative process. This shows you the final compromise perfectly. Okay, so how does a new AI system actually end up on this high-risk list? The Act lays out a very specific two-step process. First, the AI system has to fit into one of the big categories that are already defined as high risk, like employment or law enforcement. Simple enough. But second, and this is the key test, it has to pose a risk of harm to our health, our safety, our fundamental rights that is considered equivalent to or greater than the risks from the AI systems that are already on that list. Which, immediately leads to a huge question. Equivalent or greater risk sounds great in theory, but how do you actually measure that? How do you compare the risk of, say, an AI hiring tool to an AI used in critical infrastructure? Well, the AI Act actually provides a pretty detailed framework for this. Article 7 lays out 11 specific criteria, which we've grouped into the categories you see here. Regulators look at this system itself. What's it for? How widely will it be used? How autonomous is it? Then they look at the potential harm. Is there evidence of past harm from similar tech? How many people could it affect? They also have to consider the human factors, things like power imbalances between the user and the person affected, or whether a human can even step in and override the AI. And finally, they look at the bigger picture, like can a bad outcome be easily reversed? Are there societal benefits that weigh against the risks? Now, this elegant solution we're talking about, it wasn't exactly easy to come up with. The final version of Article 7 was actually the result of a 3-year power struggle between the EU's main players. It all started back in 2021. The European Commission proposed Article 7 and gave itself this broad, flexible power. But then, in 2022, the European Parliament, wanting more democratic say in the process, pushed back hard and pretty much stripped that power away. What happened next was this classic legislative tug-of-war.
which finally ended in the 2024 compromise we see today. The Commission got its power back, but with that crucial limitation we just talked about. It can only add use cases, not entire new high-risk areas. And this quote from an analysis of the Act just sums it up perfectly. This wasn't just some technical debate over legal wording. It was a fundamental negotiation about the balance between moving fast enough to be effective and maintaining democratic control. So let's zoom out for a second. Why does this one kind of technical article matter so much? Well, because it's all about trying to strike a really, really difficult balance. Here's the bottom line. Article 7 is an attempt to create a regulation that can actually learn. It's designed to be a framework that can evolve right alongside the technology it's supposed to govern. The whole idea is to protect our safety and our rights without needing to pass a brand new law every couple of years. So, what are the big takeaways here? First, the AI Act isn't a static rulebook, it's a living law. Second, there's a clear, structured process for identifying future risks. Third, it really tries to strike that delicate balance between moving fast and making sure there's proper oversight. And finally, the ultimate goal is to protect our fundamental rights as this technology just continues to explode. And listen, this isn't just some abstract legal theory. The wheels are already in motion. By 2026, the European Commission is required to publish official guidelines on exactly how all these risk criteria will be applied in the real world, which will give even more clarity to everyone involved. And that, of course, leaves us with the big question. The EU has built this adaptable machine for regulation, but as AI gets faster, smarter, and more woven into our lives, can this living list really keep us safe? Or is it always destined to be playing catch-up, just one step behind the next big breakthrough? And that's not just a question for Brussels. It's a question that could define the blueprint for tech regulation all over the world.